Hello and welcome to Chetna Bharat Learning, and in this class we're going to do current affairs for Indian polity from 4th of January all the way to 12th of January, alright? So a bunch of interesting developments that happened this week. We're going to pick three most important of them that have a very direct nexus with your syllabus in Indian polity, both for mains and prelims. So we're going to do just three of them. So the first one we're going to look at is something that happened yesterday only. The most interesting developments for this year is that the Supreme Court has suspended the implementation of the three farm laws, all right? Very critical intervention by the Supreme Court in this case, and we're going to check out whether this is justified or not. What do the scholars say, or what do the commentators say as to the justification of this intervention by this Honorable Supreme Court, all right? Then we're going to try and understand what is the role of a governor in a federal polity, specifically with respect to the act of calling a session, all right? We have done governors' roles previously also, right? But in this class, we're going to stick to the act of calling a session, all right? Session of the Legislative Assembly, and then we're going to understand what is this Central Vista case. Why are there so many articles turning up in newspapers about the Central Vista, all right? What is the constitutional issue at hand, all right? We're going to understand that also. So let's move on. So the first issue, as I told you, is the suspension of farm laws, all right? So this is in news because what did the Supreme Court say? It said that the implementation of the new farm laws, the three farm laws, is hereby stayed, all right? So there is no, so these farm laws are no longer in force right now, all right? So the court by this action is hoping that the protesting farmers which have pretty much besieged Delhi, have closed off the choke points of Delhi, they will return to their homes after the suspension of these farm laws. And the third is that the most important part of it is that the court has constituted a 4-member panel of agricultural experts, including some agricultural economists, especially Professor Gulati who's the Infosys chair of agriculture, right? They're all on this panel, and they are going to basically come up with a solution for resolving this impasse between farmers and the central government. And the farmers, the reports that are coming in is that the farmers are reportedly saying that they are not going to be a part of this panel. They're not going to interact with the panel, all right? So like, this is pretty important, right? The Supreme Court has stayed the implementation of laws, and the Honorable Supreme Court has formed a panel saying that this panel is going to decide, is going to inform us what is to be done with these farm laws, all right? It's a very innovative, it's a very far-reaching act of the Honorable Supreme Court. So, all right, so we're going to place this in a constitutional and a historical context, all right? So the important part here is that in the meanwhile, while the laws are stayed, what's going to happen is that the MSP system that was in existence before the implementation of these laws, before these three agricultural laws came into force, is going to be maintained up till a decision on the merits of these laws is taken by the Honorable Supreme Court, all right? So you understand what the Supreme Court judgment says. Now, once you've understood that, it's very important to understand what the Attorney General said in this case, all right? The Attorney General said that the court, in any case in India, the High Court or the Supreme Court, can strike down a law on one of the three grounds, right? What are the grounds on which a court can strike down a law? One, that the body that has come up with the law, or the executive authority that has passed a directive or an order, did not have the jurisdiction to do so, right? It did not have the legislative competence, all right? Second is that the law or the order is violating fundamental rights. And third, that it violates any other parts of the Constitution, all right? So the court can strike down a law when it comes to a conclusion on any of these three things, which is a conclusion that court comes to by assessing the facts of the case, the arguments proposed by both the sides, and it's a determination of the merits of the case, right? The Supreme Court did not do either of these three things in this case. It just simply went on to say that the implementation of laws has been stayed, which the Attorney General argued that the court does not have a jurisdiction to stay a law. All right, K.K. Venugopal, who's a veteran of Indian of courts, he argued this, right? So he sort of has a point, right? Court does not have the jurisdiction to stay a law, right? So what about that, right? What about the fact that the court has stayed a law, right? Are there precedents to this? Like, has the court done that in previous circumstances? Yes, the court has, right? Not so much, right? Like, there are similarities and differences, but in the Maratha Kota case, which is a 2008, 17 case, and recently in 2020 also, the Supreme Court pretty much decided that. So there was a Maharashtra Socially and Economical Backward Classes Act, where the Bombay High Court pretty much changed the quota given to a class, right? It changed the percentage from 13 to 12%, right? That itself was quite extraordinary. The Supreme Court, in the meanwhile, stayed the implementation of the law until the court comes out with a determination of merit, right, as to like whether this law shall stand or not, right? So in the Maratha Kota case, the Honorable Supreme Court has stayed the implementation of the law. Then there was an executive order through which the OBC reservation was given effect, right? Which was a Mandal Commission report, right? So in that, in fact, like interestingly, KK Venugopal was the one who argued that the court should stay the law. All right. So the court advanced hearings in that case, and court stayed the implementation of the order of the law till it was decided on merit. So there is some sort of a precedence for this, right? The court has done this in previous circumstances, right? So let's get a idea of why this is such a big issue, right? So you'd remember that in the All India Presiding Officers Conference last year, the Vice President Venkaiah Naidu came out with a big speech about how the institutions of government, the three branches of government, should stick within the realm that has been given to them by the Constitution, right? That's what the Honorable Supreme Court said. The Vice President said. The Vice President also made a specific note of judicial overreach. That the judiciary should not go beyond its powers, right? It should not come out with things like constituting committees. For example, Delhi pollution case, the court constituted a committee, right? So it shouldn't do those things because it's the domain of the executive. So there is a separation of powers element to it, right? So let's quickly understand what separation of powers is, all right? So this idea of separation of powers actually comes from a very theoretical domain, right? People wrote about it and then it was incorporated, right? It's not the other way around. That mostly what happens is that practices and traditions are theorized, right? It's the other way around. It came from a theory, right? So basically Montesquieu's theory of the separation of powers. So what he says is that power should not be concentrated in a few hands, and power should be like spread out between different branches of government, and then these branches should act as a check on others. And the second justification is functional specialization, so that not only should like these three branches of government should be separate from each other, they should all specialize in their own domains, right? So functional specialization is the first argument for separation of powers, and the second argument for separation of powers is that there should be no concentration of power in a few hands, right? And these elements should act as check upon each other, right? So that's the idea. Those are the two broad justifications for the idea of separation of powers, right? So there are two models for how this idea or this theoretical idea of separation of powers is put into practice. The first is the United States model, which is based on the Montesquieu's dictum, all right? That separation of powers, right? It's based on Montesquieu's idea. So if you look at the US Constitution, Article 1 will talk about legislature, then the second article will talk about the executive and Supreme Court. So the powers are so cleanly delineated in the American system, which actually is pretty good, but it also leads to a lot of issues, right? For example, their budgets take like so long to pass and all of that, right? So strict separation is also not a great idea. Now, then there is the British model, where people who have been elected through the legislature, some of those people end up being in the executive, right? End up heading the executive, and executive so becomes powerful, right? So the cabinet, the people who were elected through the legislature, who head the executive, like for example the prime minister, they end up being this bridge between the executive and the legislature, right? So we have this buckle mode, right? This cabinet is the buckle that fastens the legislature and the executive. So we have these two models which are predominant in the separation of powers doctrine, right? Then we have the Indian model, right? What happens in Indian model is that we have functional overlap between the three organs, right? So there are judicial functions that have been provided to the executive. The executive has many legislative functions through subordinate legislation, and the Supreme Court has been given a very active role in the constitution, right? So we have this functional overlap that all of these three branches of government are doing some bits and pieces of the jobs of the other branch of the government, right? So we have this also going on, right? And then within this difference, so you have to ask yourselves which one is the most powerful. Going by a simple reading of the constitution, you would come to a conclusion that the executive is extensively more powerful than the legislature or the judiciary. All right, and because of this scheme of things, where not only is there functional overlap, one wing is much more powerful than the other two branches. It's because of this that H.M. Sirvai, who's a very senior constitutional scholar, who was a very senior constitutional scholar and a pretty a giant of constitutional scholarship in India, he said, I may at once, dramatically, he said, I may at once say that our constitution is not based on the separation of powers. All right. So this is the state of our separation of powers, right? So many commentators have said a lot of things about whether there is a separation of powers or not. The most important commentator for us is the Supreme Court, right? What has the Supreme Court said? You need to look at two cases. First is the Ramjavaya Kapoor's case, right? 1955, where the Honorable Supreme Court said that that the Indian Constitution does not recognize the doctrine of separation of powers in its absolute rigidity, right? When it comes to a very strict separation of powers, that's not the case with us. Right, but the functions of different parts of the branches of the government have been sufficiently differentiated, right? So the court said in 1955, the court said there is no strict separation of powers, but functions are sufficiently differentiated. Every branch knows what it is supposed to do. So right, so that was the position earlier. But in 2014, in the NJAC case, where the Supreme Court struck down the constitutional amendment, the court held those many words that separation of powers is a basic feature of the constitution. So you can see this journey from it not being that separation of powers is not a part of the Indian constitution to it being a basic feature of the Indian constitution. All right. So then I sort of want to make a case that the judiciary has become immensely powerful. The power of the judiciary, I want you to absorb that fact. So let's go through some facts. All right. The first and foremost that brings this immense power to the judiciary is this plain case of the plain fact of judicial review. Right. Article 32 and Article 226 judicial review makes the Indian judiciary extremely powerful. Right. And then Supreme Court has successively entrusted or successively ensured that many elements in the constitution that were beyond judicial review became subject to judicial review, right? The first and foremost of which is the Kyoto-Holohan case, right? In the Kyoto-Holohan case, Schedule 10, where the constitution pretty much says in those many words that they are not subject to the decisions of the speaker are not subject to judicial review. In Kyoto-Holohan case, the Honorable Supreme Court said that decisions of the speaker under Schedule 10 are subject to judicial review. All right. So this is one way of Supreme Court extending its powers, right? Making judicial review applicable to things that were not under judicial review earlier. All right. So then we know that the Honorable Supreme Court and the High Courts have successively set aside laws because those laws were outside the jurisdiction of the legislative competence, right? As I told you, one of the grounds on which the courts can strike down a law, the Supreme Court has used that extensively, and many state and central laws have been struck down, saying that the legislature did not have competence to pass those laws, right? And then in Raja Rampal versus Speaker, for example, legislative privileges, right? Legislative privileges is a domain of the legislature on which no judicial interference is generally considered constitutional. It's against the norms for judiciary to interfere in parliamentary privileges. The Honorable Supreme Court has rendered them also subject to judicial review. All right. Then basic structure, right? Basic structure doctrine in Keshwananda Bharati. Not only did the court say that there is a basic structure of the constitution, the court said we are going to decide what is that basic structure of the constitution depending on the situation, right? So you can see how the judiciary is not only empowered by the constitution, but the judiciary is using judicial review to empower itself further, right? For example, in Vaman Rao amendments done to the 9th schedule were made subject to judicial review. In IR Coelho, the amendments, the laws under Schedule 9 were made examinable under fundamental rights, right? Then doctrine of due process, right? Menaka Gandhi case, not only did the Supreme Court say that that there is a procedure established by law, but the Supreme Court read into procedure established by law what due process of law, right? So due process became a part of it, right? Then in ADR case, right, 2002 case, the Supreme Court forced the legislatures, right, or the people who are trying to become part of the legislature to furnish their assets and other such details, right? So the Supreme Court has like sort of, they have to ask the legislature to also behave a certain way, right? So it has determined its behavior also. Then courts have used Article 142 more extensively than some who are comfortable with. And then judiciary often establishes committees to oversee the executive, right? So for example, Delhi pollution case and many other cases where Supreme Court has formed committees, right? Which is a very executive function, right? Executive committees are supposed to be the domain of the executive, right? The Supreme Court forms committees, right? So you can see that the judiciary is becoming powerful and powerful, right? And in this context, the Honorable Vice President said that judicial overreach is quite an issue that we should reckon with, right? So with this suspension of farm laws, if there is a takeaway, the first one is the fact that there is judicial overreach, and the conversation around judicial overreach is bound to get more and more interesting, right? For example, today Pratap Bhanu Mehta writes in the Indian Express about judicial overreach. So read that and come to an understanding of what is his argument, right? So this thing, right, because this is the third instance where the Supreme Court has stayed the implementation of the law, right? So it's going to become very interesting as to what the commentators will say. Why? Because generally there is a presumption of constitutionality, right? When the petitioners tried to get such a ruling against the Citizenship Amendment Act way back in 2019, what did the Supreme Court say? The Supreme Court in 2020 said that there is a presumption of constitutionality and we are going to check the law based on merits later, right? That's what the Supreme Court said, right? So what was what was wrong here, right? Like there should be a presumption of constitutionality in this case also, right? But that was not the case here, and the fact that the Vice President has already requested the branches of government to respect constitutional bounds is quite interesting, right? So this is the takeaway from this issue that you must, all right, that you must consider, right? Then what is the governor's role in calling sessions, right? This is very important. Then why is this in news? Is because the governor of Kerala, Arif Muhammad Khan, refused to convene a special session of the Kerala Assembly that was intended to discuss the ongoing farm law controversy, right? Now, what happened was that the Kerala Chief Minister requested the governor to call a session so that they could discuss what's happening in Delhi, all right, or pass a resolution like condemning them or criticizing them. A similar resolution was also passed by the Kerala legislature with respect to the Citizenship Amendment Act. When then also the governor sort of criticized that resolution. All right. In this case, the governor refused to give assent or refused to comply with the request of the cabinet that they should call a special session, right? So what did the governor say? The governor said, I question the urgency of the special session. And he also said that the jurisdiction, that the assembly, the Kerala Legislative Assembly, does not have the jurisdiction to offer a solution to the farmers' protest, an issue which the assembly wanted to discuss, right? So the governor is saying you don't have the jurisdiction to discuss this issue. Is that his call, right? What does the constitution say? Right. So before we get to the constitution, the bigger issue here is that this is a series of this is happening more often than not, right? So for example, Kalraj Mishra, who's the governor of Rajasthan, did the same when Ashok Gehlot asked for a special session. The governor refused, right? So in 2019 he refused, right? So we think that this is happening more and more often. So what does the constitution say, right? So this is what we have to sort of memorize or keep at the back of our minds while we are writing answers or preparing, right? So Article 174 is the key one, right? It says governor shall from time to time summon the house or each house of the legislature of the state to meet at such time and place as he thinks fit. So his power to summon the house comes from Article 174, right? And this article also puts on him the responsibility to ensure that the time lapsed between two sessions does not exceed 6 months, right? So in effect they have to meet every 6 months for sure, right? So Article 174 is where this idea comes from, right? Then there is an Article 163, right? So under Article 163, although it is the governor's prerogative to summon the house, Article 163 says that the governor is required to act on the aid and advice of the cabinet. That's it, right? Governor is he can't do things other than what he other than what the cabinet thinks fit, right? So when it comes to calling a session, the cumulative effect of Article 174 and Article 163 is the fact that governor can call a session only on the aid and advice of the cabinet, right? So this is the constitutional position. That's from a simple reading. Article 174 and Article 163 cumulatively have the effect that the governor can call a session only on the aid and advice of the cabinet, right? So there are exceptions, right? So the most important exception is that when the chief minister appears to have lost a majority in the legislative members of the house propose a no confidence motion as against the chief minister, then the governor can decide on his own whether or not to summon the house, right? If there is a special situation is that when the governor seems to have lost his majority in the house and there is a no confidence motion proposed against him, right? That is his discretion, right? Only in that circumstance would there be any discretion, right? And even his actions under discretion can be challenged in the courts, right? So what has the Supreme Court said about this, right? The most important case here is Shamsher Singh, right? Shamsher Singh pretty much settled the constitutional position, 7-bench decision that the president and governors are bound by the aid and advice of the elected government. So it settled that position, right? President and governor are bound by aid and advice of the government. So this is a general principle, a specific case of which we saw in 2016 in Kyoto Holohan, right? So in Kyoto Holohan, there was a Arunachal Assembly case, right? So the governor had imposed president's rule and all of that, and what the Supreme Court said was, in ordinary circumstances, during the period when the chief minister and his council of ministers enjoy confidence of the majority of the house, so in ordinary circumstances, when we know for a fact that the chief minister has the numbers in the house, power vested in the governor under 174 to summon, prorogue and dissolve the house, right? To summon, prorogue and dissolve the house must be exercised in consonance with the aid and advice of the chief minister and the council of ministers. So it pretty much says that, right? It's very simple. Shamsher Singh, the general principle that the governor is bound by the aid and advice of the cabinet. Kyoto Holohan, specific case where the court said, in ordinary circumstances, when you know for a fact that the chief minister has numbers in the house, in those circumstances, the governor's power under Article 174 is to be exercised in accordance with the aid and advice of the council of ministers, right? Then court read besides this, the court also said that his power to, or the idea of calling a house, is not a power but actually a function, right? It's not his discretion, especially in ordinary circumstances. It's his function. He has to do it, right? And Sarkaria Commission also pretty much said the same thing, right? In fact, the court parrots what the Sarkaria Commission said. The Sarkaria Commission also said that as long as the minister enjoys the confidence in the assembly, its advice in the matters, unless patently unconstitutional, must be deemed unbinding on the governor. So, right? So this also pretty much the same. So the position is settled, right? The constitutional position on the discretion of the governor in calling a session is settled. That is why Arif Muhammad Khan's actions raised eyebrows. All right. If his actions raised eyebrows, so what happened later is that when the government made an amended request, fortunately, the governor accepted it, right? So a constitutional crisis was averted, right? What is a constitutional crisis? When an authority entrusted with with protecting the constitution starts violating its spirit, right? What Donald Trump did, right? Like in United States. So it's a constitutional crisis that was averted because the governor accepted an amended request, right? So what is the takeaway that you can take from this incident, right? The first is that the governor can weaken federalism. These actions of many governors now, right? Arunachal Pradesh, Rajasthan, Madhya Pradesh, right? And then like Kerala and Karnataka also, right? So if governors keep acting like this, federal principle would be in jeopardy, right? This is the most important one. And then do not challenge settled positions of constitutional law, right? In Shamsher Singh, there was like, it was settled that the governor needs to act in a certain way. Kihoto Khan reiterated, then why are you bringing disrepute to that principle, right? It's very dangerous to uproot a settled principle, right? So this, right? And the third case that we're going to do today is the Central Vista case, right? So you need to understand the context of this case. There is a construction that is going to happen, right? But because that construction is to do with the parliament or the new parliament of India in an area which is inhabited by the most rich people of India, in an area where Supreme Court has special interest because it's located very close to it. So all the powerful, rich politicians, journalists, media are involved in that construction, right? Because thousands of such constructions keep happening around the country, right? Where no norms are followed, procedures are blatantly violated, but because it's so sensitive, that's why so many articles you will see by people who pretty much live in the same area in newspapers, right? So Central Vista is that case. That is why it's so important, right? But if it was just that, we wouldn't have actually covered it. There is a principle in point, right? So this case has become a display case, right? A showpiece case for what generally happens when construction has to be carried out, right? What sort of norms and procedures are followed and what are violated, right? So let's quickly get into it. So what happened was that the Supreme Court recently allowed the Central Vista project to go ahead, right? The Supreme Court gave its go ahead, right? That we agree you can construct the new parliament building, because generally it's an executive domain whether they want to construct it or not. And the Supreme Court should just like sort of take care of whether there were any laws violated, whether any fundamental rights were like involved, right? That was the job of the Supreme Court. So the Supreme Court did their job and said like, okay, you can construct the parliament, right? So it's a unique judgment in the sense that like it's 430 pages and 100 pages of that judgment are dedicated to discussion of rule of law, judicial review, and participatory democracy, right? So it's a very interesting conversation. However, in the end, what happens is like the Honorable Court appends whatever it says in the first 100 cases, right? In first 100 cases, the Honorable Court says certain things, and then in the later cases, like something very different happens, right? So the petition was earlier filed in the Delhi High Court, then it came to the Supreme Court. So it challenged the government that it had failed to follow the due process in approving the project, right? That was the challenge, right? And there were two specific claims that were important. There was 3-4 claims, but two specific claims were very important, right? From a GS perspective, right? What? First, that the state has sanctioned an alteration to the existing land use without sufficient public consultation, right? The first pillar of this challenge is public consultation, that there was no public consultation, right? The second pillar of this challenge was that the environmental clearance was given without a reasoned order. Now, what is a reasoned order? An order which provides you the reasons for where judicial mind has been applied, right? Where, for example, you say that you are going to do this, but if you do not provide the reasons for your doing that, then that's an unreasoned order, right? So there is no reasoned order, and the first principle is public consultation, right? So what the scene here was, there is a Delhi Development Act of 1957 under which this construction had to be sort of done, and it provides for a public consultation, but that is also not mandatory, right? So the law says that an opportunity should be granted to public to place on record its objections, and for those objections to be considered by like the people in charge of the construction have to consider those objections, right? That's what the law says, right? The court said there is no fundamental right involved, right? Public hearing is not a fundamental right, right? So there is no fundamental right involved, but it is only under the rigors of this law. So only even if that was violated, it was only the rigors or the procedure of Delhi Development Act that was violated. There was no fundamental right that was violated. That was what the majority said. However, the dissenting judge said something different, right? The crux of this public consultation issue was that the objections were invited from the public, but only 3 days notice was given for hearing on those complaints, right? Or, like the objections were done for only only 3 days was given for the people to raise objections, right? So the majority ruled that the law does not make personal hearings mandatory, and therefore it was irrelevant where sufficient time was given or not. So you understand what's happening? The court is saying there is no fundamental right to public hearing, right? It was just a procedure. Even that procedure was not mandatory. So even if it was violated, it's irrelevant, right? It's irrelevant whether only 3 days were given or not, right? So you can see the backhanded nature of the executive action here, right? So only 3 days were given to ensure that not many objections drop in, right? So you'd remember there was an environmental impact assessment notification where the environment ministry did not provide enough time for raising objections, and then the Honorable Supreme Court said that like this is not done, you need to extend the time, and the court extended time. So it's almost as if the court is ensuring that public consultation happens, right? The problem is that in previous cases, the court has alluded to the fact that there is something that resembles a right to public consultation, right? So the Supreme Court has in such cases had said that arbitrary state action, like deciding only 3 days notice without giving any reason why 3 days, or without giving any reasons, just giving environmental clearance, that sort of arbitrary state action violates fundamental rights, in particular Article 14. So any arbitrary state action violates what? Article 14. This has been the consistent position of the Honorable Supreme Court in all previous cases, right? So public must be given a sufficient chance to make their concerns heard. This has been the position of the Honorable Supreme Court. What happened in this case, right? That's the question. And any civic participation, like even if the public participate, they need some information to base their participation on, right? You can't just ask them to come have their samosas and leave, right? So they need some information, right? So that information was also missing, right? So the board which was doing this hearing accepted the fact that the full detailed report of the project was not made available, and they recommended that like there should be some assessment studies on traffic, environment and heritage, which were not undertaken. Right. So first there was the very exercise of the right was arbitrary, like 3 days we will tell you when. Right, and then information was not provided for exercising that right. So it seems that the court has in effect said that there is no right to public participation, right? Actually, there was no right to public participation. The point that is being made here is that slowly it was becoming apparent that the courts are converging towards ensuring that public participation is critical to most cases where public is a stakeholder, right? But in this case, the Supreme Court has overturned all of that and pretty much said there is no right to public participation. All right. So you understand this. And then the second aspect of this case that you need to understand is that the petitioner argued that because this case is of such importance that it's in Lutyens, Delhi, that so many rich people live around it, right? Because of its like incredible importance, because there's a new parliament involved, there should be a heightened judicial review, not only a regular judicial review. Like the Supreme Court should be strictly watching this case, right? And the Supreme Court said there is absolutely no legal basis to heighten the judicial review by applying yardsticks beyond the statutory scheme, right? Because the government has accorded no special status to the project, right? And the ordinary route of such development project is only taken, right? There's no extraordinary route. So there is no need or there is no legal basis for what? For heightening judicial review, all right? So like I've told you initially, separation of powers, judicial review is so important, right? So like Supreme Court has used judicial review to extend its powers. The Supreme Court in this case said, well, like let's not heighten our judicial review, let there be a simple judicial review, right? But in this case, the Supreme Court said there is no judicial review because there is no violation of fundamental rights involved, all right? And some scholars are saying that there is something of a semblance of a public participation right that exists, which has now been appended, right? So in this case, then the Supreme Court came to the fact that there is a presumption of constitutionality, right? So, and I want you to sort of like go through this, all right? The like highlighting the presumption of constitutionality of laws. What did the court say? The court noted that when the legislature enacts a law, it's presumed that it has undertaken a thorough analysis as regards the involvement of stakeholders, that it is assumed that the Supreme Court has done a thorough analysis, right? That the government has done a thorough analysis, experts and non-experts, institutions, procedures, timelines for approval, interdepartmental appeals and intra-departmental appeals. It is assumed that the court has done all of this excessively smart and like procedure heavy work, and then it has come to this conclusion that this is a law. That is the reason why the court will always assume that the executive action or the legislation is constitutional, right? That's the assumption of its constitutionality. Then what happened with farm laws? Right? If this is the position of the court, that it is assumed that the government has done its due diligence and everything, then you should not have stayed the farm laws, right? So there is this contradiction that I wanted to highlight. That is why I pulled out this part that you need to understand, right? So the court is like, it's in, so that is what will spark a conversation around the jurisdiction of the court, around what the court should do and what the court should not do, right? This contradiction is an important one for you to understand, because in GS mains they're asking very like important good questions, right, that are testing your analytical skills, right? So you need to know this. You can in fact use this. So as an example, right, the presumption of constitutionality was not applied in the farm laws case, but was applied in this case and the constitutional citizenship amendment case, right? So what is the takeaway here? One is the principle of constitutionality assumption, and the second is right to public participation. Is there a right to public participation or not, right? According to this case, there doesn't seem to be any, but like some scholars would say, if we look at like previous judgments where the courts have said arbitrary action is violative of Article 14 and all of that, there seems to be like something there, right? But in this case, the Supreme Court has pretty much gone the other way, all right? So I hope you've understood like all the three topics that we've discussed. Watch out for a good conversation on judicial overreach, all right? Because it's just going to get started. Today, Pratap Bhanu Mehta is written in the Indian Express. Check out the Hindu, what are the authors there saying, all right? So I hope you have a good day. Keep studying and take care of yourself. Bye-bye.